application contended that the petitioner had not appropriately invoked the special review jurisdiction of the court under Article 133 and Rule 54 of CI 16. Mr. Akoto-Ampao described the application as a classic case of an aggrieved party who had become emotional by the decision of the court and sought to re-argue his case through the back door by way of a supposed review. Mr. Akoto-Ampao submitted that the application was completely unmeritorious and did not satisfy the very strict conditions for review laid out in Article 133 and Rule 54 of the court. He prayed the court to dismiss the application as it was an abuse of court processes and urged the court to award a cost against the petitioner, although the case was a constitutional matter. In the ruling of the 9-member panel, read by the Chief Justice, Justice Eninyebua, the applicant failed to satisfy the court that a new important matter resulted from the reference to Article 1913 and 296 of the 1992 Constitution referred to in the ruling on February 2021. The court held that the application had failed and therefore dismissed it. Meanwhile, the application of stay of proceedings filed by the petitioner was also struck out by the Supreme Court. Former President John Mahama on February 16, 2021, filed the application aimed at halting the substantive case, pending the determination of the application for review. The court, however, ruled that the application was moot because the reason for filing it had already been granted. The court returns on Monday, February 22, 2021, to hear another application for review filed by the petitioner. The court will also on Monday's sitting set a date to deliver its final judgment on the petition. And following today's proceedings at the Supreme Court, some legal personalities shared their thoughts on matters arising.
And the grounds that counsel for the petitioner argued was that, number one, the decision of the Supreme Court on that matter was per incurium. Per incurium basically means that it was without regard for the law. And what law are we talking about? Section 26 of the Evidence Act. Because what counsel basically said was that, yes, we know that a party cannot be compelled to give evidence. That is trite legal learning, and we are all very familiar with that. But we are also aware of Section 26 of the Evidence Act, which establishes the principle of estoppel, that even though you are entitled to do something, you can be entitled to do something in law. But if by your own actions or conduct you make another person believe that you will not do that which you are entitled to do under the law, then the law must not allow you to resile from that position.
The review jurisdiction of the court is not to be granted sparingly, especially when the decision of the court is a unanimous one, that is 7-0. The scales will most unlikely tilt in your favor when you go for a review, especially when the ruling is grounded